All right, Ms. Reddy, you may proceed.
May it please the court. Counsel, my name is Vidhya Reddy, and I'm here on behalf of applicant Appellant Nguyen. In this PCR appeal, Mr. Nguyen would urge this court to conclude that Heemstra's narrowing interpretation of the felony murder statute is required to be applied, is required to be afforded full retroactivity, including to cases that were already final when that decision came down. Full retroactivity has to be afforded because in light of Heemstra's understanding of what the felony murder statute means, there is a real danger, a real likelihood that Mr. Nguyen's first-degree murder conviction and sentence were conduct that does not actually constitute first-degree murder under the statute as properly interpreted. This court has historically followed the United States Supreme Court's retroactivity framework in determining the retroactivity to be afforded to Iowa State Supreme Court decisions. It has historically, in a number of cases during the Linkletter era, applied that balancing framework in deciding decisional retroactivity for state court decisions. Now that the federal court has shifted to the per se approach, this court should formally adopt that approach in evaluating decisional retroactivity of its own decisions. Retroactivity of the Heemstra decision would be required under either approach. Under the per se approach that's currently applied under the Teague, Bousley, Shiro line of cases, procedural decisional rules are generally denied full retroactivity to collateral review because they are generally not tied with the underlying guilt or innocence of the offender, whereas substantive decisional rules are afforded full retroactivity even to collateral review for the simple reason that they undermine the confidence in the underlying finding of guilt. In this case, Heemstra is necessarily a new rule because overruling decisions like Heemstra qualify. It is also a substantive rule because rulings that narrow the scope of a criminal statute by interpreting its terms qualify as substantive decisional rules. Even under the old balancing framework that this court has previously applied, including in Everett to a collateral review applicant in deciding whether that applicant is entitled to retroactive application of a new Iowa Supreme Court decisional rule, even under that balancing framework, Heemstra must be retroactively applied. Under that balancing framework, we balance the purpose of the rule, the legitimate reliance of the state on the old rule, and the effect that retroactive application will have on the administration of justice. However, when the new interpretation of the rule raises serious questions about the accuracy of past guilty verdicts, like Heemstra would by narrowing the scope of the criminal statute, then full retroactivity has to be afforded regardless of countervailing concerns on the administrative problems that will raise.
I take it you think we erred in Guzman. And feel free, I mean, you know.
He wrote it.
I wrote it. I have a certain interest in it. But,
I remember that.
But tell us where we were wrong.
What Mr. Nguyen would urge is that this court apply that standard differently, at least under the Iowa Constitution. What this court did in Guzman is interpreted what the federal due process clause requires for decisional retroactivity, and it interpreted U.S. Supreme Court decisions as setting this distinction between clarifications of law that always apply retroactively and changes in law that are not afforded retroactive application. But the underlying concern in the Fiore and Bunkley cases that Guzman interpreted was whether the decision that retroactivity is sought on stated a correct interpretation of the statute or the governing criminal law at the time of conviction. And what defendant proposes is that the clarification of law, change in law distinction is not the appropriate test for determining whether this was the correct interpretation of the statute at that time. Because whether it's a clarification or a change, the new interpretation, if it's based on statutory interpretation and legislative intent, tells us what the statute really always meant.
I think you are telling us that Guzman was wrong, and should be overruled. It's not. I suppose a federal claim is not presented here, but
That's correct.
But you are saying that it was wrongly decided.
Correct. What I'm saying is that either it was wrongly decided under the federal Constitution, or even if it's rightly decided in that that's the federal standard or the federal test, it should be applied differently under the Iowa Constitution to more directly target that correct line in deciding what is a correct interpretation of the statute.
I mean, if I think about, kind of due process and just back up and think about it in broad conceptual terms, a lot of what we're talking about is fair notice. And it seems to me in this case, at least as to Mr. Nguyen, these events happened, I believe, in 1998. And even then, it was very well settled law that that for felony murder purposes, the felony could be the act that also resulted in the death of the victim. And so there really wasn't a fair notice problem of the defendant not being advised that the law as it stood then subjected him to potentially first-degree murder for that the conduct. I guess it was a situation where he was the driver. So help me on that.
So I don't think it's a fair notice problem because Beam and line of cases did control at that time. I think the problem and the starting point of Fiore and Bunkley is that it is a due process violation for the state not to get a conviction for an offense without proving all the essential elements of the offense. And what Heemstra did was it told us that the felony murder statute actually includes an additional element that was not recognized under the Beam and line of cases, which is that the predicate felony has to be independent. And that requires both that it be a separate act and that it have the proper chronology, and that the assault for the predicate precede the assault causing death. That is an element of what felony murder version of first-degree murder requires. And it's clear that in Mr. Nguyen's case, the state was not required to prove that element. The jury never found it. And so what ended up happening is Mr. Nguyen is now serving a sentence of life in prison without the possibility of parole for first-degree murder for what might actually have properly been second-degree murder or something less. So that's a due process problem. That's the starting point of Fiore and Bunkley, is that the state did not have to prove an essential element as properly understood under the statute.
Would we have to overrule Heemstra in part, the part that said that this case applies only prospectively into cases that are pending?
It would have to overrule that retroactivity limitation. That's not without precedent. There's a case cited, I believe, it may have been the Whitehorn case out of Montana, where the Montana court did a very similar thing, said, this prior retroactivity limitation in this prior case was improper, and we overruled that piece of it. This court has also reconsidered where a limitation on retroactivity was just kind of announced in a case without analysis on what the retroactivity standard was, has subsequently analyzed retroactivity of that rule under the link letter framework, and then decided that that was appropriate. So that's kind of what we're asking this court to do. On the due process issue, I would note that not every overruling decision would necessarily require the voiding of prior convictions under our interpretation of what due process requires. It's only those decisions that indicate that there was actually an additional essential element of the crime that the state did not prove in the prior conviction. Mr. Nguyen would also urge that Iowa separation of powers principles require full retroactivity of the Heemstra decision. The problem is not that the court undertook efforts to interpret what the statute meant in the Beeman line of cases. That is entirely appropriate in the constitutional role of this court. The problem is that once this court realizes what the statute actually means, which is the Heemstra understanding that it includes this independent felony element, that separation of powers principles limits the ability of this court to limit application of that true understanding of the statute to all litigants, to all defendants, and only to certain defendants. Not applying Heemstra to pre-Heemstra defendants is effectively saying that those defendants can be convicted of something that we now realize is not actually a crime under the statute, or the crime of first-degree murder under the statute as properly interpreted. Now, in the Danforth case out of the United States Supreme Court, the court talked about this distinction between, retroactivity versus redressability, and that retroactivity questions are really about redressability. It's not that we're announcing the temporal scope of this new understanding of the statute. It's that we recognize that there might be some violations of that are not redressable and that we can't reach back and get. To the extent that this is really an issue of redressability, I would note that jurisdictional issues, to the extent that the district court entered a conviction and sentence for first-degree murder for something that did not actually qualify under the statute, those types of errors can be redressed at any time. And so that's a good reason for arguing full retroactivity of substantive decisional changes, narrowing of criminal statutes. That's also supported by Iowa's PCR statute, which specifically seeks to grant redress even after the 3-year statute of limitations period has ended for grounds of law that could not have been earlier raised, including decisional changes as interpreted by this court in Mr. Nguyen's 2013 case. Turning to the equal protection issue, not applying Heemstra to collateral review applicants violates equal protection in 3 respects. It results in unequal treatment of defendants whose convictions became final prior to Heemstra versus post-Heemstra. It also creates unequal treatment in collateral review applicants that are relying on new substantive rules decided by United States Supreme Court decisions as compared with those dealing with substantive rules decided by Iowa Supreme Court decisions.
Your equal protection argument, if we buy it, doesn't that mean you can never deny retroactivity to a change in our criminal law?
I don't think the court necessarily has to go that far. It can, but I don't think it necessarily has to. I think the issue is in creating this distinction between pre-Heemstra and post-Heemstra defendants. The court can take into account perhaps the fact that certain defendants' convictions and judgments have become final. The problem is that we can't stop the analysis there. As the Connecticut Supreme Court said in the Lurtsema decision, no court, federal or state, has ever adopted a per se rule that we will never grant full retroactivity of any decisional rule.
Doesn't, it applies to the decisions, but wouldn't the argument also apply to the legislature? So when the legislature changes the law on what a penalty is or what the elements of a crime are, wouldn't all those persons convicted of the crime under the old law come to us and have an equal protection because they were treated differently? Because I don't see the distinction between a decisional change in the law and a legislative change in the law under the equal protection analysis.
I think the problem is that the source of definition of crimes and penalties isn't necessarily the statute and what the legislature prescribed in the statute. And so that is what has to be equally applied. When the legislature changes the statute, then that is a legitimate distinction that warrants differential treatment of those, of those different individuals convicted under the statute, the old version versus the new version. It's not the same when it's a court decision interpreting what the statute always meant, because the source of the criminal law is the statute itself and not some other.
Take your example that we decide Heemstra, and we get rid of the assaultive type felony as the predicate felony for felony murder, but then the legislature a month later amends the felony murder law and makes it. I mean, I don't know how you could distinguish between decisional decisions and legislative decisions on an equal protection argument because the legislature always can do things like that, and it seems like we'll be here, all we'll be doing is PCR cases for everybody who's in jail.
I think, again, it doesn't apply to statutory changes in the law. That might raise other, questions in terms of the relationship between the branches, but I don't think it raises equal protection concerns because of the reason that crimes and penalties are defined by statutes, and when you have an amendment, that's a different statute than existed before. Whereas when you have a court interpretation of what the statute means, that's an interpretation of what it has always meant, unless there's some intervening change in legislative intent that the court recognizes, or unless there's an intervening recognition that the statute is actually unconstitutional in certain respects. We're talking about interpreting what the statute means and what the legislature always intended under the statute. I would also note that this court has, as I said, applied the per se framework, at least in evaluating the retroactive effect that's to be given United States Supreme Court decisional rules. And that, in light of that, the court should apply the same framework in deciding the retroactive effect to be given to Iowa Supreme Court decisional rules. There is not a sufficient distinction to warrant a difference in the treatment of collateral review applicants trying to rely on substantive rules decided by this court versus the United States Supreme Court.
The U.S. Supreme Court's going to decide the retroactivity of Miller v. Alabama this term. I know that's a somewhat different context, but should we await that decision for whatever guidance might be provided?
That's possible. That's certainly within the option of this court. I'm not sure that it will necessarily get to the question at issue here, especially because this court has to determine what retroactivity rules are going to govern Iowa Supreme Court decisions.
I'm going to back up just a little bit. We're here on a PCR, so the first hurdle that you have to get over is that somehow trial counsel in this matter was somehow ineffective for not raising all of these different issues at the time of the trial. Isn't that your argument here?
Well, it's not the argument. All of those issues about whether it was raised below, whether application of Heemstra affords them relief, all of those things haven't been raised by the state. What we're here on appeal is to determine whether Heemstra may have to retroactively apply so that it's the law that defendant is entitled to use and evaluate in determining whether his conduct matched what was in the statute. All those other issues about what the implications of that mean in terms of whether he gets relief have to await further litigation on remand to the PCR court. We're just here on the retroactivity issue.
Thank you, counsel. Ms. Trout.
May it please the court, counsel? My name is Martha Trout, and I represent the state of Iowa. I'm here to tell you that you got it right in Guzman, and that there's no reason for you to depart from your interpretation of the substantive due process clause of the federal Constitution when you're considering a substantive due process challenge to the Iowa Constitution. There's no basis from which this defendant can give you any better rationale that Iowa should interpret its substantive due process clause any differently. Your Honors, when you look at Guzman and finding that retroactivity didn't apply, you found that it was a change in the law. You also, in deciding Guzman, you also upheld, reaffirmed your position in State versus Heemstra that case was to have a prospective application only. And that's where we're here. There's no basis. You have not, while you can decide to interpret Iowa's substantive due process clause differently, you have not done so in the criminal context. And this is not the appropriate case from which that you should diverge either.
What do you make of the suggestion that maybe in Guzman we were less than precise with Fiore and Bunkley? That's what I understand the argument, and that we should have focused more on the issue of what was the law at the time of the underlying conviction, and that the law is unchangeable, and the fact that we ruled in Heemstra didn't discover new law, but it really determined what the law was at the time of conviction. I'm paraphrasing your argument. You'll have an opportunity to come up and correct me again, maybe. But please respond.
Well, Your Honor, I think that, when you look at, their argument hinges on what was the law. And we would submit that the law was, between 1982 and 2006, Beeman. That was what prosecutors determined, like their charging decisions. It was how juries were instructed based on Beeman. Then, in 2006, when Heemstra comes down, the court determines that it establishes the independent felony rule. To the extent that the legislature modified the statute in 1978 and gave us our modern-day criminal code, Beeman interpreted that. That's what the legislature enacts the laws. This court interprets the laws. That's what happens. Stare decisis cannot be so rigid that you would never, ever think about some change in the law. And that's what happened in Heemstra. You decided that at this point, no longer will the same felony or the same act to support the felony will be the same act that will result in death. And you changed it. It's not to say that I disagree with the defendant that this is actually a change that he might be convicted of a crime that he didn't commit. I think that you can look at your prior decisions and you can look at the fact summaries of those particular cases to say that this was not a single shot case like Heemstra was. There were multiple shots that were fired in the drive-by shooting. There were an assembly of people outside.
But isn't that further down the line, though? And maybe not, but it seems to me now we're trying to decide the law that's going to be applied in the PCR. If we buy her argument, it's going back to the district court for you to make all those arguments, I think. So what about the fundamental proposition that goes something like this? And let's just set aside the case law for a minute. The fundamental proposition is, after 2006, people who did certain types of conduct were no longer exposed to first-degree murder. This is interpreting a statute that's been on the books for some time. It's just unfair. It's wrong for somebody in 2007 who commits a certain kind of crime is no longer exposed to first-degree murder when someone who does the exact same act in 1994 is serving life without possibility of parole. That's kind of the equitable high water mark, I think, of what's being said. How do you respond?
Well, Your Honor, I think that you've already, notwithstanding your decisions, you have rejected that line of cases that say that that it's subject to full retroactivity because when a statute or the interpretation of a statute has been narrowed, or in this case an additional element or something else has to be proven, that's just not fair. When this defendant was prosecuted, he was prosecuted under the law in effect at the time it happened. And the prosecutors and the public, had we known, we would have done things differently. And so to say now, after the fact, that this is wrong, when in fact, and you're doing it based upon an interpretation that, what we said in Beeman wasn't right. But we didn't know it at the time. So then we have to go back because worst case scenario, if in fact it is a substantive due process challenge or a success under the Iowa Constitution, every single person who's been convicted of felony murder in this state between 1982 or earlier and 2006 would want redress.
Is that correct, or would the 3-year bar apply to those who had not previously sought this relief?
Well, we thought that was correct originally in State versus Nguyen, the precursor to this.
I know, I didn't win any fans with that decision in your office.
So I think that based upon your precedent under Nguyen, if in fact, because that argument would not have been available at the time Beeman, we'll call them the Beeman defendants, had been convicted. But under Nguyen, you allowed that.
But wait a minute. Once Guzman is decided, or once Heemstra is decided, then on rehearing, once Heemstra clarifies that you have to have, it's only going to apply retroactively, then it seems to me you've got 3 years to raise the argument that that's unconstitutional. Isn't that what the statute says? At least that's an argument for you.
Right. I mean, the argument, and we made that argument initially, but in Nguyen, it all depends on how.
Nguyen was within the 3 years, the earlier
he
case. He was within the
yes.
3 years.
Yes.
And what we said in the prior Nguyen case was that Guzman was such a change in the law that it would not have been reasonable for somebody to raise a based on that. Asking us, in effect, to overrule a reasonably diligent attorney wouldn't have had to ask us to overrule this long line of cases that preceded Heemstra.
That's true, Your Honor, but just look at that's exactly what you did say as far as this upheaval. But I would say that the same is going to be true in this case if you say with the retroactive application, because you're then going to be changing what you said in Guzman relative to the federal substantive due process clause.
No. I think the point is, it is now very clear that, I mean, the 3-year statute of limitations began to tick when Heemstra was decided in 2006. Now it's clear to the world what our view is on felony murder. While prior to Heemstra, we might not expect an attorney to raise it because in Beeman and so forth we had, quite frankly, rather strong language, and that's recounted in the prior case. But after Heemstra's announced to the world, anybody that's incarcerated, arguably contrary to Heemstra, has 3 years to bring a PCR action. That's long past. It seems to me the argument is the universe of possible people who would claim the retroactivity is now closed because the 3-year statute. I mean, Heemstra got plenty of publicity. I mean, you wouldn't excuse a lawyer very easily, I don't think, from saying, "Oh, I wasn't familiar with Heemstra." So, isn't the universe of possible claimants closed?
I think that that's true now, but that hasn't prevented certain defendants. In fact, Mr. Co-defendant Dow and then Siavong, which was also part of this case, from making those allegations as well. The window had closed on those two defendants, but it didn't stop them from raising these types of claims. And the basis of by saying something that was correct at the time and how we prosecuted it or how the jury was instructed, Your Honor, while it may seem unfair, sometimes those decisions will happen and the retroactivity just won't apply. And I think that but it all goes back to like Fiore and Bunkley, which is what Guzman was decided on. In both Fiore and Bunkley, the U.S. Supreme Court remanded those cases to the individual state Supreme Courts for a determination on what was the law.
You're exactly right. The question is, what is, quote, the law?
Right.
And does it involve prior judicial precedent, which is what we said in Guzman. The contrary theory is, no, the law isn't, quote, what the Supreme Court says back at the time. The law is Heemstra, and the Heemstra law applies back to the beginning of the statute.
Well, and then I hearken back to the fact that you have, because Fiore and Bunkley were first-time interpretations. You interpreted the statute in Beeman, and that was what the law was. You reinterpreted or you reconsidered it in Heemstra. There was a growth. There was a development. That's what happens in the law. It changes. Courts make decisions, and as a result, what was the prior interpretation, which was appropriate and had been upheld for 24 years, should be interpreted to apply to Mr. Nguyen. Now, the defendant argued a little bit about the equal protection claim, and quite frankly, Your Honors, what the U.S. Supreme Court precedent stands for, and what this is, we have created a class of individuals who were convicted before Heemstra and who were convicted after Heemstra. The fact that there is this temporal break does not deny these defendants equal protection. And then also, Your Honors, as to the separation of powers argument, again, that kind of goes back to claiming that this court violated separation of powers under the Beeman decision. Initially when Heemstra came out, we had argued that you'd violated separation of powers by Heemstra. It seems inconceivable to me that when a court is sitting and interpreting the law as it is required to do, that's your job, that you had somehow violated the separation of powers when you interpreted the felony murder statute under the new Iowa Code. For all of these reasons, Your Honors, the state would request that the post-conviction court be affirmed.
Thank you, Ms. Trout. Ms. Reddy, you may present a rebuttal.
Thank you. To begin with, I want to emphasize again that no state or federal court anywhere has ever held that there is a per se rule against full decisional retroactivity. So what that means is there must be some circumstances under which full decisional retroactivity, even to people whose convictions have already become final, must be appropriate under some circumstances, though maybe not all. And so that begs the question of how we determine when we apply full retroactivity and when we don't. And in answering that question, we have to be tethered to the underlying purposes of collateral review of our PCR statute and of what the United States Supreme Court has evaluated the habeas statute. And that is these competing interests of finality of convictions versus getting to those convictions where the reliability of the guilt finding is really undermined in light of what we now understand.
The problem is this sounds kind of like a policy argument now, what you're making. And I wasn't on the court then, but I assume the court weighed all of those policy considerations when it initially decided in Heemstra that the case would not be retroactive. I mean, it could have gone the other way as a matter of judicial remedy or judicial policy. So it seems to me maybe a constitutional argument is still open to you, but as far as a policy argument, that was resolved in Heemstra, right?
I think part of the problem is it doesn't appear that way, at least from the language that's used in Heemstra. There's no discussion of how this limitation on retroactivity was decided. And what happened in Heemstra is the state had requested petition for rehearing with the limitation of retroactivity, and the court granted rehearing and ordered the change at the same time. So there was no litigation, there was no discussion about what standard applies and does this fit.
Well, it's dicta completely, I suppose, isn't it?
I believe it is. Plus, even if the court did attempt to apply some standards at that time, our contention is the court got it wrong, because one of the two frameworks it had to apply was either Linkletter, which it previously applied in other cases, including to the collateral review context, or arguably this new per se Teague, Shiro, Bousley framework. And under either of those frameworks, if we apply the Heemstra decision, either of those frameworks would require full retroactivity. Therefore, I do think that's still available. Additionally, on the common law versus constitutional question, I think there's also, just under the general doctrine of constitutional avoidance, this court would typically try to deal with the common law issue, determine what our retroactivity framework is, and whether that would require retroactivity. And if so, then it would avoid the constitutional issue. So I think in that way, it almost has to deal with the common law issue first, and then evaluate, okay, is that approach, is our retroactivity approach constitutional in light of these various considerations that are asserted? The state also discussed that, for the first time, that application of Heemstra to Mr. Nguyen's case would not entitle him to relief because there were multiple shots in this case. Again, the state did not assert that issue below in the PCR court or on appeal. Plus, in Millsaps, where this court evaluated terrorism, that also included multiple shooters and multiple shots, and the analysis there showed.
Let me ask you a question about the 3-year bar. All right. Suppose, hypothetically, we granted you the relief you want in this case. Would that then open the doors for anyone to come in who is convicted on a felony, previously on a felony murder conviction, where there's any argument that potentially they wouldn't have been able to be convicted prior to if Heemstra had been in effect. Does that open the door to anyone, or is it only people that applied for relief within 3 years of Heemstra?
I think the 3-year limitation would still apply. So they would, litigants to raise the claim would have to file a timely PCR claim. On the other hand,
You're binding the whole office on that one?
no, I'm definitely not. I'm not even probably binding myself in future cases. But so I guess those procedural considerations, requirements, I think still apply. Now, to the extent this is actually a violation of the district court's jurisdiction in entering this conviction and sentence, effectively an illegal sentence because, the sentence was not authorized by the statute, then maybe it's not limited to those who have filed timely PCR claims within 3 years of Heemstra. But of course, the administrative burdens and all that is also much more limited in that context because the remedy is different, and you're not granting new trials. You're correcting the sentence, and which is appropriate in light of the fact that the individuals are sentenced to life incarceration for what does not qualify as first-degree murder.
Thank you, counsel. The case is submitted. We'll now hear the arguments in D. Stefano versus Apartment Downtown.